going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? Wow, I butchered that. What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Yep. It's Friday night. We made it. We absolutely made it. All right. I've got let's see, what do I even have tonight? I've got two clips, both in front of Judge Green, both out of Michigan. Oh yeah, this is the attorney clip. All right. It took me a second to remember. I made this video about 5 hours ago, and then I took like a 4-hour nap afterwards. So I'm still shaking off the cobwebs here. Anyways, happy Friday. Glad you guys are here. Yeah. Really don't have too much of an intro for this clip. This attorney was the one that Judge Simpson snapped at a couple weeks ago. Now every time I see him, I watch his cases. Just he's so animated. He's got so much energy. He's sometimes fun to watch when he's not getting in trouble by judges. All right, let's watch it. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Calling case number 24-229601FH, People of the State of Michigan versus Michael Joshua Johnson. And this matter is before the court today for an evidentiary hearing. May I have appearances, please?
Good afternoon, Your Honor. Ashley Huskin on behalf of the people, P87534.
Good afternoon.
Good afternoon, Your Honor. Good afternoon to your staff. May it please this most honorable court, Edward Martell, P85051, on behalf of Michael Joshua Johnson. Sir, please state your name for the record.
Michael Joshua Johnson.
Good afternoon, Mr. Johnson and Mr. Martell.
Good afternoon, Judge.
All right, Mr. Martell, this is your motion to suppress. And I would just indicate by way of housekeeping, because I'm not certain that you, Ms. Heskett, were the attorney who handled the motion to quash. But the court issued an order denying the motion to quash, however, determined that it would treat the motion to quash as a motion to suppress with an evidentiary hearing scheduled for today. And I did notice, however, in reviewing the file, Mr. Martell, that I have the original motion to quash, which was filed by your colleague, Mr. Nasser, on August 1st, and the brief in support, which was filed June 26th. And there was a memorandum of law filed on September 25th by you. So I wanted to confirm first, are there two, I'm going to, the memorandum of law I'm treating as a brief. Are there two separate briefs for this issue?
Judge, I would say that the most recent is the most relevant and the only one I would ask this court to consider at this time in regards to but certainly I would ask the court to consider testimony, but the brief is in support of, again, suppression of the evidence upon after hearing testimony from witnesses today.
Okay, so I can just disregard the June 26th brief in support of the motion to quash and just rely on the motion to quash and the memorandum of law.
The memorandum of law, correct.
Okay, thank you.
And that was cited on, I'm sorry, that was the one filed on, for clarity, September 25th, or dated September 25th.
Yes, sir.
Thank you, Judge.
Okay, thank you. All right, any other preliminary matters?
Nothing from the people.
None for defense, Judge.
All right, then. Who's your first witness?
The people would like to call Officer Luke Edwards.
full name and spell out your last name.
Luke Edwards, EDWARDS.
Raise your right hand for me. You solemnly swear or affirm that the testimony you will give in the matter now pending.
I do.
Good afternoon, officer.
Good afternoon.
Go ahead, Ms. Hess.
Good afternoon, and thank you for being.
Before they get into it, giant shout out to the officer for wearing a suit to court instead of his uniform. You don't really see that anymore.
Where are you currently employed?
The Livonia Police Department,
And what is your role within the Livonia Police Department?
patrol officer.
And were you working in that role on the date of March 16th, 2024?
Yes, ma'am.
Where were you dispatched to?
Walmart in the area of Middlebelt and Plymouth.
Okay, and at that location, did you make an arrest?
I did.
Do you know the individual that you arrested?
I do.
Do you see him in the courtroom today?
Yes, ma'am.
Can you point him out and describe a piece of clothing that he's wearing?
Gentleman in the red shirt sitting down.
We would stipulate his identity, Judge.
All right. Record will reflect that the witnesses identified the defendant.
Okay, and when you got to that location and made the arrest,
Yeah, that's why I'm playing this clip. It's because that attorney. He makes this interesting. The case itself is pretty straightforward. The case is interesting, just nothing really too exciting. But the attorney he turns it up a notch, and it makes it fun to watch.
what happened? What did you do?
Myself and two other officers were dispatched there, and then after it was determined that him and the female half that were on scene that we had conducted a traffic stop on had committed retail fraud at the Walmart, and then we effected an arrest on both of them.
Okay, so both individuals were arrested.
Yes, ma'am.
Were they transported from that location?
Yes, ma'am.
After they were arrested, did you search the vehicle?
I did, ma'am.
And how did you search the vehicle?
As in, like, can you say that one more time?
Where did you search the vehicle at?
On a service drive. So like leaving the parking lot coming up to the main road of Plymouth.
Okay, and what did you do during that search?
I inventoried everything in the vehicle and searched it from front to back, everything inside.
Okay, and did you find anything during that search?
I did.
What did you find?
A black Smith & Wesson handgun
And where did you find that gun at?
underneath the driver's seat.
Do you have to remember who was the driver of the vehicle?
Mr. Johnson.
Did you find anything else during that search?
Nothing related to anything.
Okay. Was the gun loaded?
Yes, ma'am.
Okay. During that search, did you fill out an inventory card?
Officer Perez that was on scene is the one that handled the impound module for our impound.
Judge, I would object to what Officer Perez did unless he personally observed it. I would ask that his testimony be limited to what he personally observed or did.
Well, he didn't say that he saw the officer do anything, but I didn't hear anything that suggested he didn't know that he did it. How do you know that he did that?
I was there, ma'am.
Okay.
Do you know what that officer did with the inventory card afterwards?
We don't issue like inventory cards. The way it works when we do it is we just inventory the vehicle. It goes on the computer. You fill out an impound module and it just goes to our property and records department.
Okay. During an arrest like this, what do you normally do with the vehicle afterwards?
I told them incident to arrest.
Okay. And is it something that normally happens during the course of your role as a police officer?
Yes, ma'am.
And does the Livonia Police Department follow a towing policy?
We do.
Do you know what that policy is? Are you familiar with it?
Yes, ma'am.
Your Honor, may I approach the witness?
Yes.
What have I handed you?
The Livonia Police Department policy on vehicle towing.
And you're familiar with this policy?
Yes, ma'am.
Is that a fair and accurate representation of what the policy was on the date of the incident?
Yes, ma'am.
Your Honor, the people asked to admit proposed exhibit 1, the Livonia towing policy.
No objection, Judge. Oh, excuse me. Thank you.
It's admitted. Thank you.
Okay.
I'm sorry, did you say that was number 1?
Yes, Your Honor. What is the policy when you arrest someone?
I'll agree with you on the courtroom, but here's the thing. Their audio is top notch. you can hear the people talking in the gallery clearly. So I'm going to agree with you on what the courtroom looks like, but I'm going to give them a pass because their mics are awesome.
In a vehicle.
We are not entitled to like look for anybody to come get the vehicle. If we're making an arrest and we're blocking the road in any way, shape, or form, it's just typical to just take the vehicle and have it towed.
Okay, and on this date, was the vehicle blocking traffic?
We were.
Okay. Was the vehicle blocking traffic when you got there?
Just a moment. The question was the vehicle blocking traffic?
Yes, Your Honor.
I thought you said we were.
The vehicle and when I had to conduct a traffic stop on it in order to stop it, and then behind it and in front of it. So we were both in line in the service drive.
So your vehicle and the defendant's vehicle were blocking traffic?
Yes, Your Honor.
Mhm. So when you got there, the vehicle was not parked in a parking spot in the Walmart parking lot?
No, it was on its way out of the parking lot.
Okay. Did you follow that policy, the Livonia towing policy, on the day of the incident?
I did.
You didn't stray from the policy at all?
Ma'am?
I'm sorry, what was the question?
Didn't stray from the policy at all?
Thank you.
And at any time while you were there, did any employee or representative of Walmart indicate to you that they were okay with the vehicle being parked there?
No, ma'am.
Did Mr. Johnson ever tell you that he had permission to have the car parked there?
No, ma'am.
Okay. And does the policy require you to call anyone or to figure out another means for the vehicle to be removed from the property?
Does not.
Was there anyone on scene to take the vehicle?
It was not.
And just for the record, both of the individuals that were in the car were arrested and were no longer on the scene to take the car.
Yes, ma'am.
No further questions. Thank you.
Judge, if I may, please.
Yes.
Thank you. Officer, how are you?
Good, sir. How are you?
Great. I'm gonna ask you a few questions. If you need me to rephrase.
All right. Before we get into this entertaining show he's about to put on, Kim B, thank you so much for the 7 months. I appreciate it. Thank you so much. All right, let's go. I feel like I'm running. I'm out of breath really easily, guys. I've been battling something for the last, I don't know, 2 days maybe. So it's just keeping me down a little bit. Not feeling terrible, but definitely haven't been great over the last 2 days. So I'm trying. Let's go.
Please let me know. Fair enough?
Yes, sir.
Okay. Now, when partner, you were the OIC in this investigation or simply the one that executed the stop?
It was my call for service. Yes, sir.
Okay. Ultimately, did you do any follow-up investigation in regards to the initial call, reviewing a video, etc.?
I was the one who conducted the traffic stop when they were leaving, and I couldn't leave that scene. So that Officer Perez I mentioned earlier is the one who spoke with the loss prevention officer at Walmart and then made the scene with me, and we confirmed that they had committed retail fraud. Okay, so if there's no, how can I say this? You cannot say with certainty whether or not the female or Mr. Johnson actually drove the car to the Walmart that day. Fair enough? Drove it to Walmart? To the Walmart. I cannot say how they got there. Okay. Did you review any of the footage from when they pulled up to the Walmart? I did not review any footage. I never went into the Walmart. Okay, so you didn't review any footage as to whether or not a retail fraud actually took place? No, that was not me. Okay. Ultimately, at some point in time, you did receive a call and ultimately you pulled over a Dodge Caravan. Fair enough? Yes, sir. Okay. And certainly as the officer in charge, you did some due diligence in who owned the van, please and thank you. Mr. Johnson. Mr. Johnson was the owner of the van. Okay. And you testified at the lower court, specifically before Judge McCann in 16th District previous to this regarding this incident, yes? Yes, sir. And you recall my partner, a short guy with a ponytail, asked you some questions, correct? Yes, sir. Okay. And do you recall when he asked you, the vehicle was legally parked when you exited your vehicle? You answered, yes, sir. Do you recall that? Legally parked? Yes. I don't recall that. If I showed you the transcript today, would it refresh your memory? Yes, sir. Judge Mayer approach. Yes. Thank you.
Page 34.
I see that, sir.
Right, thank you.
You've had an opportunity to review the pages of the transcript, correct?
Yes, sir.
Okay, and you would agree, and certainly you would agree that that testimony was closer in time than today, yes?
Yes, sir.
Okay, obviously, we're a few months later now, and certainly, obviously, individuals' memories sometimes fade a little bit. Agreed?
I didn't hear you. I'm sorry, sir.
Certainly, you would agree that that was closer in time,
Yes, sir.
and certainly you would agree, obviously, sometimes memories fade a little bit with time, yes?
Yes, sir.
Okay, again, after review of this particular transcript, you would agree that you testified back in a few months back in Livonia, even about a year ago, that when my partner asked you, was it legal, or when Mr. Nasser asked you, was it legally parked when you exited your vehicle, you answered yes at that time, correct?
I did say yes to that at that time. Reading the
Thank you.
transcript.
Now, as it relates to this discussion of a third party picking up the vehicle, there was some discussion at some time from one of the officers related to a third party picking up the vehicle. You would agree?
Yes.
And that was not you, however, correct?
No, sir.
But you're privy to it, yes?
Yes, sir.
Okay, and that was between Ms. Hayes and your partner, or one of your partners, Officer Perez, correct?
It was Officer Johns that
Johns,
had that
forgive me.
conversation.
And that was previous to you executing the image or the search of the vehicle, correct?
Yes.
Okay. Ultimately, was consent sought to Mr. Johnson to search the vehicle?
That was during the conversation when Johns was speaking with Miss Hayes, I believe is the name of her. And then when they were trying to come to whatever agreement that they had for a car, then that's when we still needed to know what was in the vehicle at that point. So that's when we asked.
So I'm sorry, consent was sought by you for Mr. Johnson, yes?
Yes, sir.
Consent was denied, correct?
Yes, sir.
Okay, and then ultimately, you made the decision to essentially impound the vehicle and execute an inventory search, correct?
Yes, sir.
Okay, now, you just testified about executing an inventory. Now, you started the initial inventory, correct?
Yes, sir.
But you didn't, after finding this weapon, you didn't complete the inventory, you would agree?
I was there present with the inventory, but Officer Perez is the one that documented the items listed within the vehicle and did the actual impound module for our records department. We were both on scene for it though when it was conducted.
Okay, and I draw you to your initial testimony where you testified that it was actually you that found the weapon and then Officer Perez that continued the remaining of the inventory. Do you recall that testimony?
Yes, sir. I was there for it.
Okay, so you didn't complete an inventory report, correct?
No, he completed the impound module.
Okay, and you say impound module. Now, you're very familiar with your impound policy, yes?
Yes, sir.
Because you just cited it and ran through it with sister counsel, and obviously you're well versed in it. You would agree?
Yes, sir.
Okay. Now, 502.9 vehicle inventory. Your testimony here today is there's no actual inventory report, but an impound module, correct?
Yes, sir.
Okay, is that something that your officers do traditionally, or is that something that you've reviewed within the report and found to be factual protocol?
As in, is that something we do every time? Is that what you're asking?
Is that something that your department has done traditionally, or is that something you researched within the report, within your policy, and found to be protocol?
Traditionally, in the policy, if a vehicle is being towed by us due to an arrest, then we do an inventory impound module.
Inventory impound module. Now, has that inventory impound, and certainly that inventory impound module would list the items that were found within the vehicle, correct?
Yes, sir.
Okay, can you state with specificity what was actually found within the vehicle other than a firearm? Was there, children's clothes? Was there diapers? Do you know what was in the vehicle?
There was other miscellaneous items, but I'm not the one who wrote it all down to.
Miscellaneous items. So you can't say with certainty what was within that report. Fair enough?
Yes, sir.
Okay, and you have a hunch that he did that report, but have you actually read that report?
I have not gone through to see what else he wrote down for the impound module.
Was that report tendered to the people?
I don't know what you mean by that, sir. I'm sorry.
Was that report that you're attesting today that your fellow officer drafted or created tendered to the prosecution, the prosecutor's office?
Like, was it given to them?
Correct.
I'm not aware.
So today, as you sit here today, you can't say with specificity whether a report actually exists or has been tendered to the people. Fair enough?
Well, no, Officer Press did it. When our dispatch enters it is impounded, and we take a reference number and it goes to the property records department.
Understanding, but you personally didn't do that report. Fair enough?
I did not do the report, sir.
You
No.
personally have not read that report. Fair enough?
I have not read the report. No,
And
sir.
for clarity, you personally can't say whether the people are in receipt of that report, correct?
I cannot speak on if they have it or
So
not.
you have no firsthand knowledge that the report actually exists, other than the fact that you believe your partner to have done that. Fair enough?
Yes, sir.
Now, ultimately, you did execute a search, yes?
Yes, sir.
Okay. Once that search is executed, again, my client was where, in the backseat of the vehicle at that time?
He was either already being transported to the jail or he was still in the back of B.O. John's vehicle. One of the two.
And you were the one that removed both occupants for the vehicle?
I removed him and Officer John's removal with Trailheis because she was a female, so she just conducted a female search and handcuffed her right there.
Fair enough.
I'm sorry,
Yes,
you
sir.
both are talking really fast. Officer, you said that you removed Mr. Johnson, and then after that, what did you say?
Officer Johns is a female officer, and since the other arrestee was a female, she just handcuffed and searched her right there because it's just, we have to have a female search regardless.
Thank you.
Now, Mr. Johnson was removed from the vehicle first, yes?
Yes, sir.
Placed within the back of the vehicle?
Yes, sir.
Ultimately, within your police report, you didn't note any furtive gestures or any wild movements. Certainly, if he was doing that, it would have been in your report, correct?
Yes, sir.
Okay. Ultimately, a follow-up investigation, I'm sure, was done.
In terms of,
Well, let me be more clear. Was DNA fingerprints taken, either one?
I don't handle that. We have our own crime scene unit that handles all of that.
Are you aware of any evidence related to that as far as DNA or fingerprints?
As far as me packaging it as evidence and tagging it, that's the last I've touched it or seen it.
So for clarity, you can't say with any specificity whether any exists, yes?
As in fingerprints or DNA?
Correct.
I cannot tell you if there is any that exists.
Okay. And no ammunition was found on my client, correct?
No, sir.
Bullets, no holster?
No, sir.
I'm sorry. Officer, you're the officer in charge.
Yes, sir.
Would the officer in charge be the only one who would order the testing of DNA and fingerprints, et cetera?
I'm just the arresting officer. I handled the case. It then goes to the detective bureau, who it was Sergeant Heenanen that was in charge of it.
Okay.
And then when the evidence goes to our crime scene unit, one of the officers assigned to that unit is the one that handles all the evidence. And then if there's follow-up reports to be done, they do it on their own. But in terms of like warrant requests or anything like that, the detective bureau handles all that.
So we've been referring to as officer in charge. What would that mean? Officer in charge of what?
This was just my call for service and case report.
Oh, I see. So we have a moniker for the detective who is in charge of the investigation as the officer in charge. You are not that person. Is that correct?
I would not be the officer in charge of the entire case.
Okay, thank you.
Whoa, isn't that special? I don't know where you get this we from. I mean, I just think he's okay. He's just okay. We didn't say anything about loving the guy. I mean, he's an okay guy. I mean, be careful when you drop the wee bomb. Man, I'm messing with you, Logo. Good to see you.
Who is the officer in charge?
I can't remember how to spell it correctly, but it's Sergeant Heenanen. I can get that to you.
Heenanen?
Heenanen, yes, sir.
And he is not here today, correct?
He is not here today, sir.
So ultimately, again, no fingerprints, no DNA, no holster, no ammunition, no furtive gestures. That would all be correct, yes?
Yes, sir.
And he was removed from the vehicle prior to this young lady being removed from the vehicle as well, correct?
Yes, sir.
And then, was the vehicle ultimately towed?
Yes, sir.
Okay, and when it was towed, were tow cards issued and provided to the tow truck company as well as one to the prosecutor?
Again, tow cards, I don't understand. We don't have anything that I can think of that we call that. If you
Well,
could,
for clarity, what within your policy, what type of mechanism do you use according to your policy?
whenever we have a vehicle towed, I give the case report number, which is the one assigned to this case, to the towing company. And then they jot that down and they keep that as their record for each case number that they come out and do a tow for.
And that's, again, something done traditionally, or that's something you know to be in accordance with the policy?
So I was taught to do it, and that's how we're all trained to do it, is you give them the case report number, and that's how they take care of their billing and their records of how they maintain how many cars they've towed.
Understood. Judge, I don't believe I have any further questions. Thank you, officer.
Yes, sir.
Just a couple more questions. The inventory module that why do you do that?
For like personal liability for the city and to inventory and write down everything that the person has in the vehicle in case of any like theft or damage or anything like that.
Okay. And do you have the discretion to tow or leave the vehicle there?
We do.
And why did you decide to tow the vehicle this time?
We were blocking traffic, and if I were to even try to move the car to go park it, I would have either had to do like a 4 or 5 point turn to turn around and then drive back to the parking lot and park it, or go on a main road to drive it to go back into a different driveway to go. And I'm not driving somebody's car like that. And we had just arrested them, and they just committed retail fraud. So either there's stuff in the vehicle that could be in there or not, unknown to me. But at the end of the day, like we're not required to find a route to do it, and I'm not going to be responsible for their car getting broken into in the parking lot after I leave.
Thank you.
Yes, ma'am.
Judge Mayer, very briefly.
Yes.
Thank you. But officer, to be clear, you did testify not once, but here previously, but also here today, that car was legally parked, correct?
If I said that before, then I was mistaken.
Okay. Thank you. And also, officer, just for clarity, Officer Johns did have some discussion with Ms. Hayes about a third party ultimately picking up this vehicle, correct?
To my knowledge,
And you don't know exactly what that discussion entailed, correct?
just somebody coming to pick up the vehicle.
But you're guessing at that. You don't know exactly what
No,
you
it was
discussed with them.
they discussed having another person, a third party, show up to take the vehicle
Okay, so ultimately there was at least some consideration for that at that time, yes?
for Officer Johns. Yes.
And ultimately that changed when that inventory, when consent was denied and the inventory search was then conducted, you would agree?
Because I didn't know what was in the car, and for liability reasons, I don't want his property to get broken into, and I never even looked to see what was in the car.
So you want
I made the mistake of, listening to the attorney when he said it was going to be very brief. Lone Wolf, this is Michigan. I don't know what city this is. The judge's name is Judge Tracy Green, I believe, and it's a circuit court. No idea what city it's in, though. I'm guessing it's in the area because this is the same attorney that we see in all the surrounding areas. He just got in trouble in Judge Simpson's court a few weeks ago. So somewhere in the area, I would assume.
wanted to get in that car before you let that third party take away the vehicle, yes?
I just, before the third party was even there, or just to know that I'm not allowing him to have his stuff stolen or anything like that. We've had instances like that in Livonia in the past where exact scenarios like that occurred, and the officer didn't go in the car, and then it came up that the vehicle was allegedly broken into and hundreds of dollars were stolen and like jewelry and stuff like that. And it ultimately comes back on the officer for not verifying that this person has valuables or money or anything in the vehicle.
But
So,
again, you had the authority to let them release that to that third party, yes?
if there was a third party on scene,
But at some point, again, Ms. Johns and Ms. Hayes had that discussion.
when they were up at the window, when I was placing him in my patrol vehicle, yes, sir.
Thank you. No further questions, Judge.
Just one more question. Is it still,
Just one more. Go ahead, thank you.
is it still your discretion if it's illegally parked for you to tow it?
For private property and like public roads, it's different, but yes, ma'am.
And was this on private property?
It was on the service drive coming out of the parking lot, right just south of Plymouth, so,
Thank you.
yes, ma'am.
No follow-up, Judge. Thank you.
Oh, thank you. Oh, I do have a question.
Yes, sir.
The inventory module that you described. Is the information that is inputted in that module capable of printing?
I believe so.
So if the court wanted to see what used to be called an inventory card, which is
Yes.
from your testimony, obviously no longer being used, inventory cards, the information goes into this module. So if the court wanted to see the inventory for this vehicle, what would happen? How would the court get that?
We have our own property and licensing and records department, and I believe just simply, I believe it would be a FOIA, or I don't know how it works with the court getting that from, but I believe it's all on file. It's all in a computer, so.
Okay. So the point of my question is just to determine whether this information is obtainable and reviewable by third parties, which would include the court.
To my belief, it should be obtainable without really any, shouldn't be hard.
Okay, thank you. All right, you're excused, sir. Thank you.
All right, thank you, Your Honor.
Please be safe out there.
Do I give this back to you?
Yes, please.
Yeah, I covered her this morning. No. She had a landlord tenant docket today.
Ms.
It was just
Heskett?
meh.
Do we have any other?
But yesterday's docket was good. I have another clip I'm gonna probably release tomorrow from her docket yesterday. But yeah, DeSanto's back on YouTube. So celebrate. Yay.
Witnesses?
No further witnesses.
Does Mr. Johnson have any?
No witnesses, Judge.
We'll have argument. Ms. Heskett?
Yeah, the clip I played this morning didn't make Judge DeSanto look good at all. And when I watched it the first time on, I released it this morning. So when I watched it for the first time yesterday, in my head, the guy lied and went to jail. And then rewatching it, it was like, oh my gosh, Judge DeSanto's trying way too hard to violate this guy when it's clear he didn't. But yeah, didn't make her look good at all.
So firstly, I would like to reference the Supreme Court case of People versus Tui, which is 438 Mich 265. In that case, states that it's clear that an inventory search is constitutional when it is in accordance with otherwise reasonable policy department regulations. Officer Edwards just testified that on the date of this incident, that they followed the Livonia towing policy, which was admitted as Exhibit 1. Per section 502.4, it says arrest scenes. Whenever the owner or operator of a vehicle is arrested, the arresting officer should provide reasonable safekeeping by leaving the vehicle secured and lawfully parked at the scene, or when appropriate, by having the vehicle towed, such as when the vehicle presents a traffic hazard, is in jeopardy of theft or damage if left at the scene, or when a private property owner would likely not consent. On the date of this incident, officer just testified that the property owner did not consent to leaving the vehicle on the property. He just testified that previously there has been instances where cars have had theft and damage done to them when left at a scene. And he said that the car would have been left on service drive, which would definitely present a traffic hazard. Additionally, Mr. Johnson was the operator of the vehicle and was being arrested. So per the towing policy, officer was allowed to tow the vehicle. There's also case law that is analogous to this current situation. I have People v. Owens, 2007, WL 3274700. This is an unpublished opinion, but it is very similar to the case at hand. In Owens, the defendant was parked at a gas station that he did not own and was on private property, and he was arrested. The court held that it was not reasonable for the defendant to assume he could leave the car parked at that location, for which he has no control over, and nor could it be assumed from the facts of the case. That is similar here. Officer Edwards just testified that Walmart alleged that Mr. Johnson and the female in his car had just committed theft against the store. Going off of those facts, it's reasonable to assume that they would not want the vehicle left on their property or near their property. Further, there's no duty to find an alternative to towing the vehicle per the tow agreement. The policy states that the officer does not have to find, quoting, officers are not required to investigate whether alternatives to towing a vehicle exist after an arrest. Officers are encouraged to impound vehicles to protect the owner's property and city's liability. When considering whether to leave a vehicle at the scene, officers should take into consideration public safety as well as the reasonable safety of the vehicles and its contents. Again,
Is that still Owens?
this is part of the vehicle towing policy
Guys,
under 502.4 arrest scenes, the second paragraph. As officer testified to today, public safety and the reasonable safety of the vehicle and its contents, leaving it on the road where it was pulled over and the arrest was done, leaves it liable to having an accident occur, it being broken into, and it's just a safety hazards for drivers that are on the road. Further, Walmart did not consent to keeping it there. It was Walmart's private property. It was not Mr. Johnson's property. Officer Edwards also testified that there was no one there to take the vehicle, and no one from Walmart told him it was okay to leave the vehicle there or gave consent to it there. I think that he testified that it was in his discretion to do so, and given all of the facts of the case, that he decided to tow, and that was the best option. As to the defendant's challenge of the probable cause nexus between the gun and the ammunition and the defendant, I think that all the facts here show that probable cause has been met. The defendant was the registered owner of the car. The defendant was in the driver's seat at the time of the arrest. The gun was found under the driver's seat, and the gun contained ammunition in the magazine. So just because it wasn't on his person, possession can be constructive, and it was definitely within his reach in the vehicle. For all the reasons I just gave, the people request the honorable court deny defendant's motion to suppress. Thank you.
I think it's an issue because if you get the towing thrown out, then they never did an inventory of the car, which means they never would have found the gun, therefore no firearm charge. So they were, it was a retail fraud, so they were suspected of, stealing from a store, and that's what stopped the traffic. That's what caused the traffic stop. Then whatever happened, they got arrested and they towed the car, so they did an inventory on it. That's what I'm guessing is going on. So if they throw out the tow, they can't be charged with the firearm.
Thank you.
If it pleases the honorable court. Judge, respectfully, first and foremost, I think it's undisputed that a warrantless search took place. Obviously, consent was sought, consent was denied. Now, once there's a exception to the search warrant requirement, which is what the inventory search is, Judge, it has to be.
Yeah, no, they do. So that's what they're arguing. If they find that the tow was illegal, then the inventory would get thrown out, and they couldn't charge him with the gun charge. And again, that's just what I think is why he's arguing this.
Be done pursuant to TUHI, and it's certainly all the case laws within our memorandum. But pursuant to TUHI has to be done in accordance with departmental policies. Now, Judge, it's the people's absolute burden of production, and I applaud this honorable courts wanting to, inquire to the officer about, about this module and about the inventory. But today is the date and the time for the evidentiary hearing, and today is the date and the time that they really should have had this for the court to review, because it's the people, respectfully, their burden to produce. And failure to produce that inventory search is really a Brady violation, because it's exculpatory evidence at most. But Judge, certainly it's necessary to get past this inventory or this search warrant requirement. In order to get to the next stage, there has to be, again, an exception, and the exception is the inventory search. But the very basis or reason for an inventory is to produce an inventory. And I respect this officer for being honest, but he was not the one that produced, that gathered the inventory, produced the inventory. When asked what was actually inventory, his answer was miscellaneous. He couldn't say for certain what was actually on that inventory list or whether or not it was ever given to the people. That's a problem, Judge. Because absent that, Judge, what we're stuck here with is people be pooled. It's a ruse for rummaging, especially considering the fact that his partner had a conversation with the young lady regarding a third party taking the vehicle at some point, but after consent was denied, that was off the table. So certainly we can see the officer's mindset that he wanted to get in that vehicle. Now, what basis would you need to check an inventory for if it's going to a third party, be it that a family or something? It's really kind of moot. But notwithstanding all that, Judge, without the inventory, I don't believe we can get past the inventory search exception, because, again, it cannot be used for rules for rummaging. People be pooled, and it's the people's absolute burden. Notwithstanding the fact that it was legally parked, and notwithstanding the fact that, again, as it gets to the actual people be wolf, knowledge, dominion, and control, constructive possession, that he was the first one removed from the vehicle. He was the first one to remove from the vehicle. This young lady was left in the vehicle. And when she was left in the vehicle, ultimately, really, this officer was, how can I say, dealing with Mr. Johnson. Mr. Johnson didn't have no furtive gestures. There was no DNA. There was no fingerprints. There was no ammunition. There was no holsters. There was nothing, Judge, to indicate just simply mere ownership of the vehicle, when actually he wasn't even, they don't even know who drove the vehicle there. But I don't even think we get there, Judge, because we don't have an inventory. And today was a date and time to produce that. It's not here. Without an inventory, there's no inventory search exception. And for those reasons, Judge, I think this unlawful search must be suppressed. Thank you.
That was a good argument, and this is why I wanted to play this attorney. We watched him and Judge Simpson just a couple weeks ago make a complete ass of himself, and he does a good job. I don't know what he has against Judge Simpson. There's clearly clearly something going on between them, but he's not a bad attorney. Just on that day, it was not his day, and it wasn't the first time in front of Judge Simpson that he was an ass. So no idea. But that was a good argument. Let's see what the judge says. Oh, also real quick, Durball, I am so sorry I missed this. I don't know how I missed this. I just saw it starred. I'm like, wait a second, I didn't see this come through. So Durball, I am so sorry I missed this, and I don't know what you're kidding anymore. I'm guessing you sent this at 8:30, so this was 15 minutes ago. So yeah, but I appreciate it. Thank you so much for the super chat. Oh, I'm not saying he's right. No, don't worry. I'm not agreeing with
Just
him.
briefly.
I'm just saying he did a good job defending his client there.
The tow card or the towing modular is to give to the tow lab. It doesn't have anything to do with the officer's ability to do the inventory search. What we're arguing is the officer followed the policy, which People v. 2E says that excuse me. It's clear that an inventory search is constitutional when it is in accordance with otherwise reasonable policy department regulations and is not a subterfuge. Officer Edwards testified that on the date they followed the Livonia tow policy, we read through the policy and stated all the different reasons that it was valid on that date. The tow card doesn't seem to be what's at issue here. So.
Judge, may I very briefly rebut?
Yes, but she's gonna get the last word.
Fair enough. Judge, I think, and I got much respect for the people, but I think we're conflating the tow card with the inventory report. Two separate issues, both very important. And I'm not sure either one was followed, but certainly the inventory is of the utmost importance because how can you have an inventory search exception if we don't have an inventory? And while he may have a hunch or think that the other officer executed same, he couldn't state with specificity what was on that inventory list because he didn't inventory. He couldn't state with specificity that he didn't testify. In fact, he testified he did not see the inventory list or draft report. And he can't state with specificity whether or not it was ever tendered to the people. And in speaking with them, I don't believe it ever was. And I certainly haven't received it. So Judge, without that inventory, we cannot get to the next stage. There's no exception. And for those reasons, Judge, it must be suppressed. Thank you.
Your Honor, the testimony that the officer just gave is that the inventory was done. Just because he doesn't remember the details of exactly what was in the inventory search module doesn't mean that the search was not done. The search was done. It was done per policy, and the car was towed.
Please. All right, we are going to recess and come back for ruling on December 18th at I have a hearing that day that will be in the afternoon. But I'll say 4 p.m., but it might be sooner if that's better for the parties. I'll be here in any event. So we'll say 4 p.m. on December 18th, and that would be by Zoom. This is just the court's ruling.
I forgot about this, guys. I am sorry. We do not get a ruling right now. Oh, which is fair. Judges are allowed to do that, and it allows them some time to actually go over all the laws to figure out if, what they can and can't do. So, man, I forgot she didn't rule on this instantly, though. And isn't that special? This is circuit court, so this is a felony charge. So I don't know exactly what the gun charge is, but it's a felony gun charge because it's circuit court. All right, this one's almost over. And then I've got a pro se in front of the same judge. Pro se right after this.
Thank you, Judge.
Thank you, Your Honor.
Thank you. Oh, I'm sorry.
Look at him being
Mr. Johnson,
respectful.
Does that date and time work for you?
You said
December 18th, at 4 o'clock on Zoom.
4 o'clock.
4 p.m. Yes.
Yes.
We'll see everyone then. Thank you.
Thank you, Judge. Have a great day.
You too. Thank you.
All right. Yeah, that was. I don't know why. I thought in my head I knew who won that. I did. Like I knew who won that, and I kept wanting to say, "Can't wait to show you guys the end." Apparently, I just dreamt that. Must have been during my nap today. I have no idea. All right. Last one. That one was a long one. This one's only about 10 minutes. This is. I'm pretty sure this is still Judge Green. If it's not Judge Green, it's Slave. It's Green. Okay. This this is just a pro se idiot. And it. Yeah. Let's just go.
We don't remember what happened. do we?
Yes, I do. You don't know. She stated that. That's all that. When you tell me you have that, you transfer. You say taking stuff out. You say you don't have to travel. You do stuff everywhere. These years you have it. It's crazy. I just want to know what it is. Just want to know. Why won't you take it? What you mean? I'm fighting a case. It's a contract. Just go ahead and if you hear it down. I'm sorry. It's just so hard to represent someone. Like I talk to her,
Sorry for Watson. Calling case 2400.
All right, I left that in there on purpose, just because that's how good this courtroom's audio is. You could hear them whispering together, and I don't know if you heard everything they said. I couldn't, but the one thing the attorney said is, "I'm not trying your case. Like, you went pro se. Stop complaining to me. It doesn't sound like you remember what happened." It was that made me chuckle a little bit.
05381, People versus Sean Watson. We're here for final conference. Appearances, please.
Good morning, Your Honor. Natia Scott for the people, P78816.
Good morning.
Good morning, Judge Renee Cooper, on behalf of Mr. Watson. Why don't you give us your full name first?
Mr. Watson, good morning, sir. Will you please state your name for the record?
Sean Watson.
Good morning.
My contacts with Mr. Watson, Judge, are such that I am of a belief that he is not competent to go to trial and would like a forensic evaluation done. And I'm pretty firm on that. He is extremely upset that he's not going home today. I don't know where he needs the forensic evaluation, but he is so angry at me that unless they can start somehow making him take his medication, which he just won't take.
You said you talked to my sister. Tell her you talked to my sister. She said you talked to my sister. I'm get the bond for the $50 10%, and you talked to her that weekend. We never discussed nothing about no forensic. I don't need no forensic. I'm trying to get my bond reduction. So
Mr. Cooper, do you need additional time to speak with Mr. Watson?
yes, no.
No, Judge, there isn't any. If there is some desire to have him start all over again with another lawyer, I'll gladly step aside. But he and I talking, I'm saying he's not competent and can't help me.
So,
And
so Mr. Watson, when and there's an issue of competency, the court can't proceed. And what Mr. Cooper is saying is that he believes that you are unable to assist him in your defense. Go ahead, Mr. Watson.
Okay, so listen, right, on the last court, you had told me, you was gonna give me the bond, 50,000, 10%. If this guy would talk to my sister, he talked to my sister, and she said I can live with her. So I'm trying to get out so I can get a fair trial. I can get my lawyer once I get out. He don't pick up the phone. I'm trying to give him a chance, but we can't build. You know what I'm saying? This guy haven't come to visit me.
Can I
haven't
just
seen him.
withdraw?
So you know what I'm saying? It's like he's trying to railroad me, but I'm trying to use him so I can get a fair. I'm going to get a fair trial, Jimmy. But I'm trying to, you know what I'm saying, prove to you that.
Yeah, Bertie, you're not blocked. I can see you. You're not blocked. I know. I paused it because it's the second time you said that. It was the second time I've seen it. You're not blocked. I'm sorry you think you are. Also, apparently this guy's not pro se. I'm the idiot. I just remember this guy standing by himself at this table and complaining to the judge. That's what I remember. That's why I said pro se. Apparently I missed the whole first half. Now this is even more interesting.
You know what I'm saying? Yeah. Innocent. I'm innocent, but I need help. I need to get out on teller. You could put me on GPS teller. This dude spoke to my sister. And you know what I'm saying? I'm just trying to get a 50,000, 10%, for me, affordable bond so I can get out. I'll be able to get, you know what I'm saying? Attain my own lawyer. I'll work and everything. That's all I'm saying. I'll come to court dates every day, all that. You know what I'm saying? I'm not incompetent. I don't need no medication. Yes, ma'am.
You've been prescribed medication, Mr. Watson?
No, I don't. I used to take it when I was a kid. I used to take it when I was in prison. I've been off medication since 2013.
Okay, so here's where we are. There was a pretrial services referral on October 24th, and there was a hearing scheduled for that for October 28th. Defense counsel was ill, so we moved it to November 15th. Odyssey indicates that it was held, but I see an order dated November 18th where the bond was denied. What I'm willing to do, Mr. Watson, is go back and look at that tape, that recording, and if I indicated that I would re-evaluate bond after having heard information from your sister, then I will schedule this to come back for a bond hearing for me to take that into consideration. Now, that's not to say that I would give you a bond. That's to say that I would reconsider it with additional information, and I would fairly consider it. So, Madam Clerk, let's set a date to come back for bond hearing. And I'm going to hold off on any order for evaluation of competency because I believe that there is miscommunication between counsel and Mr. Watson.
I think that's very fair, Judge.
Okay, so we'll come back to Mr. Watson on December 17th. And I will have had enough time to review that recording. And please invite your sister to join us on that date.
I try my best to.
And
works
she
with
can join us
7-7.
by Zoom.
Okay.
What's your sister's name?
Neely, Miss Nilly, Nina Nilly, Nina. She worked from 7-7, but I'm calling her tonight and let her know like I need her, you know, participate if she can step off work or
All right,
anything.
if she's unable to do it, she can send a letter, just something indicating what it is that you expect her to indicate to the court, okay?
Judge, may I just add that on September 17th, that was the first preliminary examination that was held in part. The previous attorney did ask for that judge to mark the file medical. And I'm also asking in terms of the next hearing, if we can come noon or later. I have a preliminary examination with 2 defendants that starts at 10 a.m.
What time would you like?
We can do noon or later.
We do one.
Let's see. 1 p.m. 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 1 Yes.
All right, guys. I'm gonna there's only about a minute left of this. Yeah, I kind of what's the term I'm looking for? Words are hard. I took the easy way out tonight because I was just tired. And yeah, kind of threw this video together. Didn't really watch the clips, as you can tell. I have no idea what's going on. And usually I at least know. Yeah, so I do apologize for mailing it in tonight. I am under the weather a little bit, so please forgive me. I don't have anything else to say. You guys are awesome. Thank you so much for hanging out with me tonight, even though these cases were meh. So I do appreciate it, and I will have a better show tomorrow and Sunday. I promise. I've already got good videos made for tomorrow, so I don't even have to think about them. They're already uploaded and everything, scheduled to be released. So that's good. And then we'll be back Sunday night. Tomorrow night's date night, so I will not be live. And I will see you guys Sunday night. Oh, Members Monday won't be happening Monday. I'm gonna have to do something else for the members this week because Bengals play on Monday night. So yeah, even though the Bengals really aren't that great this year, I still watch them. I'm still a fan. I'm not a bandwagon. All right, you know what? While I'm paused, let's look for someone to raid because this clip is over. And I know if I hit play, I'm gonna miss it. Looks like we have. It's Friday night. Usually there's more people live. Is Lone Wolf the only one on right now? I just refreshed. Yeah, Lone Wolf's the only one on right now. It says KCC's coming up, but it doesn't tell me what time. I wish it told me what time the people that were coming up were starting. All right, we'll go to Lone Wolf again. All right, you guys have a great rest of your night, and yeah, I will see you Sunday night. If not, one of my videos is a premiere tomorrow, so I'll hang out in the chat for a little bit tomorrow, and yeah. So I'll see you guys for my next live on Sunday night. You guys are awesome. Until next time, bye.
We can do 1 o'clock.
All right.
And by marking the file medical, Ms. Scott, you meant, what did you mean by that? Was that mental health or physical health?
It was my understanding that it was mental from the previous attorney, but I don't recall if those are her actual words.
Okay. Well, we'll see what Ms. Neely has to say. I'm sure that she would know. All right, we're off the record.
Thank you.
Thank you. We'll see everyone December 17th.